Thank you all for coming. I'm very happy, very pleased to be here with former colleagues and good friends. I'm going to be very brief. I will limit my remarks to secure transactions reform and also to, specifically to our OAS secure financing project. This initiative was launched last year in 2012 as a component in a broader effort to introduce the necessary changes in the legal frameworks and policy machinery that help micro, small, and medium-sized enterprises access the credit they need to expand their businesses, thereby inducing economic growth and also social welfare in both Latin American and Caribbean countries. Towards that end, we are here today sitting in this table trying to find ways to build effective partnerships with global players and also both regional and international players, because we seek to extend our regional outreach by supporting and working together with other international organizations involved in secure transaction reform. The project focuses on improving the capacity of member states to implement secure transaction reform based on the OAS instruments on secure transactions, which are there outside if you want to take a look at them. There are the OAS model law on secure transactions, its model register regulations, but we not only limit ourselves in our project to this instrument because we have a broader reach and we also want to promote secure transaction reform based on other international secure transaction instruments. What do I mean by these other international secure transaction instruments? Well, there has been a great explanation by Christophe and also by Spiros of the instruments that the Hague Conference on Private International Law and the United Nations Commission on International Trade Law have promulgated under their auspices. Both these organizations have been very successfully active in preparing instruments, legal instruments that can have a decisive impact in secure transactions and other similar financing transactions. So, which are these instruments? Well, some of them are dealing with general matters related to secure transactions. Probably the most well-known is the UNCITRAL Legislative Guide on Secure Transaction, a very comprehensive law governing both the creation and third-party effectiveness and priority and enforcement of security rights. But there are others, like the Supplement on Security Rights and Intellectual Property and the UNCITRAL Legislative Guide on Implementation of a Security Rights Registry that have been recently adopted. We also have, as Spiros mentioned, the draft UNCITRAL model law on secure transactions, that this project is still continuing. But also we have some other more specialized instruments that are the Hague Convention on the law applicable to certain rights in respect of securities held with an intermediary that are also very important. So I think that these instruments, of course together with our instruments, should be taken into account and very much considered by just the persons that are engaging in transactions that are governed by them. That is the case of those instruments which have the force of law. But there are other instruments that don't have the force of law, but they also should be considered and taken very seriously into account, because these instruments most likely will anticipate legal developments that will be effective one day probably in your country. And so the practitioners should be taking into account these instruments very seriously. And Now, moving further to our capacity building seminars. In the context of our OIS Secure Financing Project, the objective of this seminar is threefold. First will be to explore the ways in which both stakeholders and experts can work together and can assist, and of course beneficiaries of the reform too, can assist in the implementation of those instruments. We also want to present some preliminary studies comparing existing laws and practice with the requirements of these instruments. And finally, we also want to present, as a result of the working groups that will be set up specifically for that purpose, practical recommendations. I want to emphasize practical, because for us it's very important to face the challenge that in a day-to-day basis the beneficiaries, the ultimate beneficiaries of a modern and effective secure transaction system will be facing in utilizing this new system, this newly introduced system. And how basically these practical recommendations will help reform their local law and practice. We focus on capacity building because, of course, countries, and that's the first step, should be willing and flexible to change. But skills and, of course, education, training remains very critical. We have a very distinct approach, which is a broad-based participatory law reform approach. Meaning we want to have, namely, we want to have a global network of experts and stakeholders. We want that the local champions that are key for our purposes, and also the government officials, could meet and have an interactive dialogue as the one we're having here today with their global peers. We are happy now to announce that El Salvador has agreed to become the first primary beneficiary of this initiative, and in this capacity will be hosting the first capacity building seminar next April 2014. I see the potential role of both the UNCITRAL and the Hague also as threefold. I see that they have tremendous expertise that they could provide in the implementation of their respective instruments in participating member states. I also would like to see their expertise with regard to the manner in which both their instruments and our instruments, the regional instrument adopted by the Organization of American States, can work jointly. And also, thirdly, I would like to see this expertise in the manner in which member states can jointly adopt both these international, global, and regional instruments. That's why we encourage also the participation of member states to participate in the working group on security interests of the United Nations Commission on International Trade Law, working group number 6, and we, as well as in other regularly scheduled meetings of the Hague Conference. And finally, we also, that's pretty clear, but we also encourage, in addition to the OIS model law and our instruments on secure transactions, we also encourage member states to adopt the instruments of UNCITRAL and the Hague on secure transactions. And we are happy to also explore other avenues for cooperation and collaboration in this field that could materialize in research project or technical assistance delivery. For example, with regard to the recommendations that will emanate from the working groups in the capacity building seminar that we'll be hoping to host, organize both in the Caribbean and also in Latin America, of course. And if you have any other questions, also if you would like to have some additional information on our current ongoing initiative, I have left some brochures, informative brochures that you could find there. There's also more information available online. Just please visit our website or contact us anytime, or the Secure Transactions team. So thank you so much for your consideration.
Well, perhaps now we can open the floor.